Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast isn't legal advice, but I will tell you that nothing will prevent me from giving you an easy to understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. This episode's topic is UNUM, and UNUM, much like other disability carriers, has a history of arbitrarily denying disability claims. If you've got a policy through UNUM, this is the episode for you, because this will give you insight as to the games that UNUM will play with various types of claims. I'm going to be telling you about 4 stories that I think illustrate the games that UNUM play. But if you don't have a UNUM disability policy, don't tune out. These are also games that other disability carriers will play. It's in the Disability Carrier Denial Handbook. First, I'm going to start with talking about the 5 reasons that UNUM used to justify denying a long-term disability claim by an emergency room physician with breast cancer. Second, I'm going to talk about how the lack of diagnosis and the ability to work in other medical facilities doomed an urgent care physician's claim for UNUM disability benefits based on multiple chemical sensitivity. Thirdly, I'm going to talk about a vertebral compression fracture and wedging claim that was denied by UNUM and ultimately overturned by a federal judge. And last, I'm going to talk about UNUM's claim that a policyholder's back pain was out of proportion to evidence of radiculopathy on exam was reversed by a federal judge. Let's take a break for a moment before we get into this exciting episode about UNUM. Welcome back to Winning Isn't Easy. Let's talk about how the lack of a diagnosis and ability to work in other medical facilities dooms an urgent care physician's claim for UNUM disability benefits because of multiple chemical sensitivity. A disabled policyholder or plan beneficiary has the burden to prove that they're disabled as required by the terms of the policy or plan. And I'll be frank, that can be very hard to do in a multiple chemical sensitivity claim. What is multiple chemical sensitivity? Well, it's an unrecognized and controversial diagnosis. It's characterized by chronic symptoms attributed to an exposure to low levels of commonly used chemicals. Unfortunately, the symptoms are vague, they're nonspecific, and they can include things such as fatigue, headaches, nauseousness, and dizziness. There are several theories that explain the cause of multiple chemical sensitivity, and that can include allergies and even neurobiologic sensitization. Nonetheless, there are terms that in a disability policy or plan that are going to be in play in a MCS claim. And these policy or plan terms can make it even more difficult to get your disability benefits. Let's start out with a common definition of disability. It's the inability to perform the material and substantial duties of your regular occupation because of sickness or injury. Now, this definition, in my opinion, has 2 key terms. The first term is material and substantial duties, and the second is sickness. A disability carrier is going to start their analysis of the claim by determining whether you have a sickness, which is commonly defined as an illness or disease. Now, continuing on this line of thought, disability carriers will dispute the diagnosis of multiple chemical sensitivity as not even existing, but certainly not being the equivalent of an illness or a disease. It can be particularly hard to prove that one has an illness such as sick building syndrome or multiple chemical sensitivity. Often there aren't any objective findings for the physical reaction to workplace exposures. You could be exposed to cleaning agents, fragrances, chemical irritants, sanitizers, pesticides. And I will tell you that's a particular problem because I happen to be allergic to substances like colognes and certain types of detergents. When tested by my allergist, my testing is normal, but if someone comes into my office wearing perfume, I can lose my voice. In fact, it's so bad, we tell people not to come into my office if they are wearing perfumes, colognes, or that sort of thing. The problem, of course, is that multiple chemical sensitivity isn't even recognized as an illness by some physicians, and many disability insurance companies have position papers that dispute the legitimacy of MCS and the diagnosis of MCS. Now, as I've said, one of their first lines of defense is going to be you don't meet the policy definition of sickness or illness. But the second line of defense is the inability to perform the vocational demands of your occupation. What the carrier says is, look, you've got the burden to prove that you don't have the capacity to perform the material and substantial duties of your occupation. And we're going to question whether you could perform those occupational duties with a different employer in an environment without the exposure to the chemical irritants, or whether there is some other reason why you can't work in a different kind of environment. Now, if they can show that you can work in a different environment, that maybe a different location, a different employer, they're probably going to deny the claim. And that's going to be particularly true if the policy definition of occupation is the inability to perform your occupation as it's normally performed in the national economy, instead of how you perform it for a specific employer or a specific location. Because generally, that's the problem. It's generally something that's at the workplace environment that is a trigger. And if this definition is in play, you're going to have a much more difficult time in getting your benefits. The disability carrier or the plan administrator is going to take the position that it doesn't matter what you're exposed to at your employer's place of business or your reaction to that environment, because that's not the standard definition of occupation. In other words, the work environment is not material and substantial to the duties performed in your occupation. Now, the plan or policy may not require, under the definition of occupation, that you perform your duties at a particular location or in a specific environment. And if that's the case, the courts are going to bite on this argument that disability carriers make, and they will uphold a denial of an MCS claim. That's exactly what happened in the case of McFarland versus UNUM Life. This is another Washington state case. McFarland worked as an urgent care physician, rotating among various facilities. He had specific reactions at just one of their medical facilities. His physicians didn't really give him a diagnosis, and even went so far to say that, look, he could practice medicine so long as he avoided exposure to chemical irritants. He filed a claim, and of course, UNUM denied the claim on the basis that there was no diagnosis and no proof that he was unable to perform his occupation as that term was defined in the plan. Of course, this case ended up in court, and the judge upheld denial on the basis that McFarland could, and in fact did, practice medicine so long as he limited his exposure to chemical irritants and avoided certain facilities. The judge also noted that the building in question had been tested for air quality in the past, and that didn't help McFarland's case. So you can see how difficult chemical sensitivity cases or sick building syndrome cases can be. You've got to look to the terms of the policy, the definition of sickness or injury, and certainly the definition of occupation. Let's take a break.